Good afternoon, everybody, and welcome along to this edition of Lair Confidential on lairmedia.tv, and info@lairmedia.tv is our email, and you get all our programs up on our YouTube channel. I'm absolutely delighted to have as our special guest today, Mr. Cian O'Carroll, all the way from the Premier County, Cashel in County Tipperary. Welcome, Cian, to this program.
Hi, Pat, and thanks for having me.
Great to see you. Now, I mean, you're a Tipperary man. You grew up in Tipperary.
Grew up in Cashel. Eighth generation.
Cashel King Cormac's, yes.
Cashel King Cormac's. Wouldn't be very knowledgeable, I'm afraid, on matters GAA, but yeah.
That's all right. Thank God this is not a GA program, anyway, because as we were saying before we started.
I've got the answers for you.
And how many were in the family growing up?
Just myself and my older sister. She's just a couple of years older than me, and
right. And your mum wasn't there. And you lost your dad when you were 19 in a fatal accident. He was electrocuted. And how did that impinge on yourself then, growing up, and your family?
Well, it was a huge change, and I suppose I learned a number of things from it. First of all, it changed my outlook on life, because up to then I had been pursuing very little in college with abandon, and I was really going down the tube. So the poor man passed away thinking that his best efforts with his only son had pretty much come to nothing, and I was failing repeatedly. And so I think it did wake me up and make me cop on a little bit in that sense. But the other thing it really showed me was the very profound effect that type of incident has for the survivor, for my mother. I saw her aging 10 years in the course of one morning and never really recovering from it, So those kinds of lessons are useful in the work I do now, because it's very helpful if you can sometimes put yourself in the shoes of others and have a sense of what they're going through.
Yeah, I can't even imagine. But you were in college. Were you in college in Maynooth, was it?
I was doing a science degree in Maynooth, and at that stage I'd gone to college very young. I was only 16 when I went to college.
Oh, really? That's very young.
Well, perhaps that contributed to my lack of maturity and the very poor performance as a student. But in any event, I ended up doing a 3-year degree over 5 years. So bad was I. And in the end, left with my degree. But by then, through the experience of Dad's death and the civil action, the legal case that my mother took from that, I had now got my first taste of and experience and brush with the law, and was very interested in that. So I was fortunate that my father, who had provided for me really through pensions and the like, he was a very prudent man financially, and that enabled me to go on to further studies in law.
And that whole court case, it worked out all right, did it feel?
It didn't really, no. It was successful, but what it taught me was that clients are not always best served by their legal representatives, and it also left me with fairly serious scar damage or scar tissue around the area of legal costs. And
oh dear.
I think that was certainly the motivation for me, having a fairly strict rule that our clients do not pay anything from their compensation or proceeds, even though the Law Society say I'm not supposed to say that, that I do not believe that where a solicitor is paid costs in a case by the losing side, as is the normal process, I don't believe it's appropriate, based on the experience of my family, that they should then have to hand over anything from the redress, which is usually pared back to the very minimum that's required to kind of put them back in the position that they should be in, but for the loss anyway. So they certainly shouldn't have to pay some kind of success fee to their lawyers.
So if I got €50,000 awarded to me for whatever it was, that's it, that's all mine?
Oh, absolutely. And as part of that award, there may be exceptional circumstances, but I mean, I really don't come across them. Um, the award would include an award of costs. And so those costs are comprised of the various outlays that you've had to spend to progress your case, like medical report fees or an engineering report or things like that, witnesses who may have to come to the trial, the barristers that we would engage in the case, and our own fee. And all those things get put into a big bill and it goes off to the other side. And as you can imagine, it's another negotiation. So things are pitched a little bit higher than you expect to end up at, and the other side then offer you less, and eventually you reach an agreement. And those are the costs paid, and you can make an appropriate living from that without turning around and asking your client for money. But as I say, that's simply the way it's done here, and I think a lot of other practices, but not all practices.
Yeah, and there's been some disquiet as regarding compensation and awards and all of that, about particularly with insurance companies who settle outside of court, you know, as we call it, the steps of the court. And the person, like if I was involved in the case, I might know nothing about the settlement until my insurance company informs me of the settlement. Do you understand?
Yes. You're talking about a car accident, for example.
Yeah, and I've met two people fairly recently, and the first thing they knew about it was when they got a letter from their insurance company that 50,000, whatever, has been awarded to Cian because you brushed up against them. Now, of course, that's bad enough, but when they come to renew their insurance, then it's anything. It's just a made-up figure out of the sky. So is that unfair? Should the person who owns the car, has the policy, surely they should have some say in whether this can be settled or not? Had they any recourse in law to this, what we call an unfair award against their insurance policy?
Well, if they have an issue, they could raise it with the insurance ombudsman. But remember that an insurance policy is a contract of insurance. And that contract has terms which are agreed to by the insured, by the individual taking out that policy of insurance. Now, they may have very little bargaining power. So if I go to one of the big car insurance companies and I look to insure my car for a year, if I don't like a term that's in the policy, such as one that says, you know, we retain the right to settle this case without recourse to you or without regard to your concerns. If I go to them and say, well, look, I'm really not happy with that, I want that taken out, I presume they will say to me, no, that's a term that stays in, take it or leave it. So in that sense, if you don't have much leverage in a negotiation, it seems very unfair to you, but it's a commercial operation. The insurance company is there to make a decision. I would say that nobody in my experience gets 50,000 euros for being brushed up against. And while there's an awful lot of talk about the high level of compensation in the Irish legal system for individuals, an analysis of the figures doesn't bear that out. I think my own experience is that more minor injuries and a lot of whiplash injuries tend to fall into the more minor category, thankfully. Things which are resolved and gone away and are just a bad memory maybe 18 months after an accident. Yeah. Those types of injuries receive disproportionately higher compensation than they would in the UK and in some other European jurisdictions, but not all. We're not outliers there. Where it's different, however, is that if you take a catastrophic injury, which is what most of our cases are dealing with,
yes,
injuries at a really distressingly high level for the people involved, the general damages there, the damages for your pain and your suffering, is capped at 500,000 euros.
Oh, I see.
That just got reaffirmed by the Supreme Court in the Ruth Morrissey case, because the state was arguing with laboratories that it shouldn't be even 500,000, it should be 450,000. And that means that a person who, for example, has been injured maybe they've been struck by a car as a pedestrian and they're paralyzed from perhaps the neck down. They might have 30 to 40 years of life expectancy in that condition, unable to do anything for themselves, entirely dependent. They may have ongoing pain, fully aware of that every day of their life for 35, 40 years. And the law says they are not entitled to more than €500,000 for compensation. That's to give them the extras in life. Now that breaks down at something like 12,000 a year, which is really a very paltry sum indeed. In the north of Ireland, it's €75,000 if you convert it to euro. Sorry, 750,000 euro. So it's 50% higher even there. And people say that they're the model we should be aspiring towards because the UK is supposed to be low compensation. So I think the compensation argument, the damages argument, is a lot more complex than the PR companies that revive this issue on behalf of the insurance industry on an almost yearly basis would have us believe.
And you mentioned the Ruth Morrissey case. Is that concluded now?
That is concluded in almost all respects. There's certainly no difficulty in talking about it. I just say that because we're working on, there's a further minor issue that relates to an issue between some of the defendants, which the Supreme Court is still waiting for some submissions on, but all of the main issues have been concluded.
The law has spoken on it.
Yes, and the law has been clarified in most respects. In one particular issue, which has quite broad-ranging effects, it hasn't been entirely clarified, but most people see the Ruth Morrissey action. It's Ruth and Paul Morrissey against three defendants. There was the HSE, there was Quest Diagnostics, which is one of the laboratories that cervical smear checking was outsourced to. They're based in the US. And Medlab, which is part of an Australian-based global consortium of laboratories, but they're based in Ireland, in Sandyford in Dublin. And the case was, if you want me to outline it.
Oh yeah. I found it very, very interesting. I was reading a small bit on it, you know.
Well, it's hugely important, and it actually affects a much broader range of litigants, of people involved in litigation, than just those affected by the cervical check scandal. But in Ruth and Paul's case, the allegation that was made was that two slides, which had been read, had missed an opportunity to send her forward for diagnostic tests, which would have found that she had early stages of precancer, which would have then turned into cervical cancer. And had that been done, it would have been caught at a very early stage. And not only would she have been spared a lot of the surgical intrusion and treatment that she suffered, but her life would have been saved. And that case was chosen, I think, by the defendants to be a test case. And as a result, even though there were mediations before the case began, it kicked off and it ran for, I think it was 36 days. And I'm told that's the longest medical negligence trial in Irish legal history.
36 days, God, that took its toll, did it, Cian?
It's difficult, you know, continuing with the case through that. My colleague solicitor here, Siobhan Ryan, was running that case, and I was involved in it too, but Siobhan Ryan did the brilliant work on that case, and together with the rest of the legal team, Patrick Tracy and Jeremy Marr were our senior counsel, and Ciara McGoldrick, the junior counsel. And just as a team, everybody worked well. Our clients were wonderful. Ruth and Paul, very courageous, never demanding, and always encouraging, and quite a grateful or a thankful couple as well. Thankful for all of the good things they have in their life, and then thankful for the work that was being
done,
put into that important case, which is nice to be acknowledged. Anyway, the trial concluded with the judgment of Mr. Justice Kevin Cross, and that was a resounding victory for Ruth and Paul Morrissey. However, shortly after then, almost immediately after, one of the two laboratories announced, like a reflex, that they were appealing. and the
Oh, go away.
the other two defendants also appealed. So normally the course is to appeal to the Court of Appeal. And then if there's an issue with the Court of Appeal's judgment, a legal issue might be referred on then to the Supreme Court.
Yeah.
In this situation, because Ruth was so gravely ill and it was already being treated as an extremely urgent case, the Supreme Court was asked, would they accept it in the first place and jump over or leapfrog the Court of Appeal? And that's what happened. So the Supreme Court then, back in December last, had set aside 3 days for legal argument on that. And there were very detailed written submissions, and that was concluded. And then in, I'm struggling to remember, was it March or April of this year that it got and,
every day is the same since February.
Well, we weren't there for, so the courts had their access restrictions in place. So it was probably late March. And again, it was a resounding success for Ruth and Paul. And most importantly, the Supreme Court, I think, clarified how you look at the test when you're considering whether a screener has done their job properly in cervical screening. And there had been a lot of debate within the medical profession in particular following Judge Cross's High Court decision, where he had said that the test was, as a shorthand expression, was one of absolute confidence. And a lot of people came out and said, doctors can't have absolute certainty in anything they do because it's not a matter of certainty. And that's correct. The judge hadn't said absolute certainty, but even if he had, it was just a shorthand expression for a type of test, which effectively means that if the screener, who is not a doctor, is looking through their microscope at that slide and something gives them pause whereby they don't have, something causes them to doubt whether that slide is normal. If they have a doubt, they cannot pass the slide as normal. They must then pass that slide to a doctor, to a consultant cytologist who is part of the team to review. And the doctor then makes the decision based on the ordinary standards of negligence. And that was the outcome from the Supreme Court, which was effectively reaffirming that decision from the High Court.
Well, that was very good. That was a very good outcome, of course, you know. And of course, you wouldn't, Dr. Scally wouldn't be a big fan of yours, even though he, you know, the inquiry that was done.
I do know of Dr. Scally, certainly. I've never met him.
And I saw you clips of you on RT, you know, answering questions, obviously, you know, with that whole. There were so many inquiries, there was so many meetings, there was so much happening around it that it must have been every twist and turn. There was something new being added to the scenario, and I think that it's unfortunate that people wouldn't. It's part of our litigation system here in Ireland, I suppose, but it is changing for the better, in my opinion. Although I have very limited experience, that people don't put their hands up early enough and say, look, hold it here, lads, look, we made the mistake, or we did this, or we did that, or something like that, to save a lot of heartache. You had a case, of course, you had the Vicky Phelan and Gillian O'Sullivan cases as well, all over that period as well, Cian. I mean, that must be very challenging on a human level for you.
Well, could I just go back to that point you were making about so many investigations or reports? There really weren't. And my continuing objection to this day would be that there has never been a correct or proper investigation into what happened in these laboratories, let alone what was going on in cervical check. You see, remember, when this scandal broke, and it broke due to the courage and determination of Vicky and Jim Phelan. And then the announcements that followed after that caused a cascade effect where it became very clear that things were not being run correctly within cervical check. And calls came on very quickly then in the Oireachtas for an inquiry. A promise was given to the Dáil. The Dáil voted for a public inquiry.
That's right.
And in order to determine the terms of reference of that public inquiry, it was decided that the public health specialist, Dr. Gabriel Scally, would be engaged to conduct a scoping exercise over a short period of time. And that scoping exercise would then set the terms of reference for the public inquiry.
That's true.
Somehow that got converted into Dr. Scally will inquire. But Dr. Scally's scoping inquiry was never given the powers or the terms of reference to actually delve into the key issues in this matter. The key issues were not giving some stamp of approval to the laboratories as to how they're performing today on a statistical basis, which is what his report does. It was to look at the errors which had occurred. And Dr. Scally, people will be surprised to hear, I think, and I even heard the Minister for Health about 2 years ago on a radio interview contradicting me on this. So I got it in writing from Dr. Scally through a press release that he issued, confirming that he has never seen a single medical record for the 221 women who were affected in the initial.
That is astonishing.
Nor were any of those slides ever reviewed by the investigation team. So what you have now is a situation where there has been a look at the laboratories. A report sets out why the laboratories seem to be performing normally, but none of their mistakes are investigated, which would be the exact same as if, for example, an airplane crashed on landing at Dublin Airport and there were 221 people on board. And the Irish Aviation Authority said, we don't need to investigate this accident because we know from the statistics that Irish airspace is just as safe as it is in America or in Australia. You completely ignore the actual event because the events, critical events, are always hidden. I mean, if you look at the percentage of people who die in airplane crashes in a year, it's minuscule. I mean, you really just couldn't take any heed of it or learn anything from it. It's so small. And yet, every single near miss, never mind an accident, is investigated to the nth degree so that you can find out why it happened, how it can be avoided again. And then the learnings from that are disseminated through the entire industry very quickly so that everybody learns from each potential accident, let alone an accident. And we didn't do that here in Ireland. And our health service and the subdivision of that, cervical check, seemed to be quite happy to close their mind to that. We have documents where they said at an early stage that Vicky Phelan's case was not a critical health issue. This was not something which related to anything they needed to learn from. This was just a statistical blip, and that continues to be their view of all of this. We do our job fine, keep going, keep moving on, and don't learn anything from these, despite the fact that now we have perhaps 24.
Well, I don't know whether you want to comment or not, Cian, but we have the same chief medical officer in charge of the COVID-19 who was in charge of the cervical check debacle.
Well, to be fair to Dr. Holohan, I mean, he wasn't in charge of cervical check. He was obviously involved in the government's response because he is a civil servant in the Department of Health and he's the chief medical advisor to the government. But I don't think you could say that he ever had any role in overseeing quality assurance in cervical check. And what Dr. Scally said about quality assurance in cervical check is that it was, quote, non-existent. And he said that in an Oireachtas committee. So while quality assurance was a major problem, I have yet to be reassured that it is no longer a major problem. And part of that is because when Vicky Phelan walked out of court that day in April of 2018, at that stage, the Irish screening program had only 45% of its screening being conducted in the US by Quest Diagnostics. It now has 90% being conducted in the US by Quest Diagnostics. And it is being done under what appear to be the same quality assurance guidelines and being done with the same absence of any independent inspector from Ireland at that laboratory.
And Cian, it's very disquieting to hear that at this stage as well. I really don't know how to ask a question around that because it's astonishing.
I don't know that there is a difficulty with quality. What I'm saying is that People need to have confidence, and that simple issue continues, that it's all being done the same as it was, and we're being asked to trust in the statistics. And yet we know that there are now 24 women who have died so far as a consequence of what have been publicized by Cervical Check as serious misses and misreadings of slides. They're not necessarily all negligent, although the vast majority of them are in that group, in my experience and in my opinion. But I can't say that they're all negligent, but they have all been found to be opportunities that were missed to lead to an earlier diagnosis. And as a consequence, that many women have died, and all the others have been very seriously harmed, very seriously harmed.
So what would be your opinion today on the cervical check screening setup that we have right now today for women going to this? Would you express confidence in it at a small, medium, or large level?
I think what's happening at the moment is good, which is that the state is moving towards a national laboratory which will return cervical screening to the state sector. And I think that there is a problem when things are being done far away. The state prior to 2008 had a network of about 14 laboratories who were all engaged in cervical cytology. And as part of the creation of Cervical Check in 2008, 13 of that 14 were shut down. And the scientists who were working in those laboratories and had expertise in reading cervical cytology, no longer having cervical cytology to work on, they moved on to other areas.
Oh, I see.
Lost. Yeah. So as a consequence, Ireland could never compete again for these contracts that were being handed out. It had to go out to the private sector. And as I said before, that was principally to that laboratory in Sandyford and the ones in the US. Without proper oversight of those, as noted by Dr. Scally, problems arose and issues with quality assurance weren't being detected, let alone acted upon back home in Ireland. We don't have enough reassurance that that is no longer the case for me to make any bold statements. But at the same time, I have no desire to be raising alarms over something which you would have to assume, even if only because of litigation, those laboratories were being perhaps extra cautious. There has been so much attention focused on those mistakes that one would have to be hopeful. But there is one major continuing problem that I see with the way that program is being rolled out in Ireland, and that is the audit. There was an audit being done within Cervical Check where women who were diagnosed with a cancer following a clear smear were being flagged quite correctly, and their old smears were now being pulled and looked at to see, did we miss something here? And
right.
That's how the 221 women were identified. It was through that audit. That audit was stopped immediately after Vicky Phelan's judgment, or case rather. It was a settlement, not a judgment. But immediately after that, the first action that Cervical Check took was to stop the audit. Now, they said it was because they hadn't been disclosing properly to women the existence of the audit, and therefore they needed to figure out how to do that before restarting it. But we're 2.5 years on, and it still hasn't been restarted.
Really?
During that period of time, over 700 women have been diagnosed with cervical cancer, and none of those have had the benefit of an audit to look back to see was an opportunity missed to diagnose them earlier. And I think that there is an incentive for the screening program and for the HSE and even for the Department of Health to delay the restarting of that audit, because they don't want to have to acknowledge that there are probably quite a large number of women in that group who have been diagnosed over the last 3 years, say, with cervical cancer, who have not had an audit, and yet who will be found to have had a missed opportunity earlier in their care. And I think that's very wrong. We shouldn't have a situation where the state is trying to present itself as being really interested in open disclosure to women, while actively denying anybody who's been diagnosed in the last 3 years from finding out if they were failed.
And just before we finish the cervical check scenario, to clear up in my own head. So my test, I go in and get my test done. It's sent off to the laboratory in America. And I presume they all come back somewhere for checking, for results. The results come back. Where did they go?
But interesting. For example, you go to your GP. A sample is taken using a brush and placed into it into a vial. That vial is then sent for processing. It goes to the laboratory, or sometimes there's pre-processing done in Ireland. It goes to the States. Then a slide is manufactured, is made in a machine, and that's then examined under the microscope. Results were actually, for MedLab slides, we know that those results were being read at one stage in America. For example, Vicky Phelan's slide was read in Texas. At a time when the Irish company was in existence, the slide was coming back, the slide stayed in America. The result on paper was being transmitted back to Ireland and then was being certified by a clinical director on behalf of the company who was certifying paperwork. Presumably the people involved in the system knew this, but nobody was actually certifying the clinical action of reading the smear. It was being certified as a paper exercise. And
so,
which that had a role in the errors, I can't comment.
So I go into my GP, the pre-test and all that. I presume eventually when I go back into my GP to get, what's up here, doc? Where's my results? Do you have to go back in, or does your GP eventually get the result of your smear test?
Oh, yeah. The results come back to cervical check, and from there they are sent out to the doctor and the patient. So the woman receives her results on a letter from cervical check telling her that your result was normal, and then depending on age, told really what the next interval will be for. So you will be invited to come back for another smear in, say, 3 years if you're a certain age. And if there was an abnormality, well then depending on the degree of that abnormality, there will be a different direction as to what should happen. Either come back in 3 months for another smear, or 6 months for another smear, or it may be to come in for an examination of the cervix using a microscope called a colposcope in the process of colposcopy. And that's how a diagnosis is made. So the smear doesn't diagnose cancer.
Yeah, I know that.
It's just picking up.
Yeah. So that's the process explained for our viewers and our listeners. And I hope, listeners, you're listening to Lair Confidential, and with me today, fantastic Cian O'Carroll. Now, Cian, can a 13 or 14-year-old citizen of this republic be arrested on the street and taken into custody?
Yes, they can. And the circumstances under which they can be detained are quite limited. You're referring, I presume, to the death in custody of Brian Rossiter.
I am indeed. It was sensational at the time, and it still is lingering, I suppose,
And there was a news story today at lunchtime, and it involved a photograph of the Garda station in Clonmel, and immediately I was back there and thinking about him. And he was very small. He was very little, and he was treated very badly.
He died.
Served very badly by the state. And I think ultimately at the end of a 6-year legal process where we had a very complicated inquest, a judicial review relating to the inquest, an inquiry that ran for over a year, and a civil action that ran on for several years. At the end of that, the family still didn't get an answer to the key question, which was what caused his fatal injury. The inquiry, like a lot of things, a bit like what we've just been talking about with the scoping inquiry into the cervical check matter, the state directs a lot of things away from itself. And in that case, the then Minister for Justice, Michael McDowell, announced an inquiry under the then brand new Garda Síochána Act. And problems were pointed out with the way that was going to work. And then suddenly it was going to be under the Dublin Metropolitan Police Act of 1928 or something like that, a 100-year-old piece of legislation now, which was really just a disciplinary mechanism against Gardaí. And as a disciplinary mechanism, they had to be charged with certain offences. And then the inquiry was to look into that.
Right.
And one of those was effectively accusing them of assault. And how do you prove assault against people? You have to have a high level of evidence at the criminal standard, which is beyond a reasonable doubt. So those Gardaí were put into an awful situation, because anyone who's accused of something as serious as that wants to clear their name. And
that's right.
It's very difficult to do that. The family were put into an unfair situation because they didn't have a mechanism now to inquire more broadly. Not that they should have been the ones inquiring, of course. The state should have been inquiring.
Absolutely, yeah.
They set up this thing where basically we were the plaintiff and they were the defendants. And I know it was very, very difficult on the family. And I also know it was very difficult on those Gardaí, because they were named and they were known to have been involved. And I think it was largely because they were on duty.
But was there, sorry, Cian, for cutting across you, just to emphasise for our viewers, Brian Rossiter was 14, just to emphasise. I think I mentioned 13 or 14. Brian Rossiter was 14 when he was arrested. But surely, in Gardaí, I'm an ex-civil servant myself, so I have a small bit of understanding. There was somebody in charge of the station that night. Surely the person in charge would be held responsible for the actions of the Gardaí. Sergeant in charge.
Yes. The difficulty there is deciding what were the actions and what were the consequences of those actions from the night. So I'm trying to be fair here and not take advantage of a situation where one could just, we've moved on 14 years, people have clouded memories of these things, and I don't want to give the impression.
Well, that's fair. That's fair.
It was clearly established as to what happened. I mean, the facts here are that Brian, on the weekend before school was restarting, his mother and his siblings having just moved down to Wexford, he came back to say goodbye to his school friends. And having been a young chap of pretty good behaviour, that summer he had been starting to get a little bit into slightly. I think he had one incident where a Garda car pulled up and asked him to empty his pockets or something, and there was a packet of cigarettes that was thrown away, and there were no drugs or anything involved.
Yeah.
Like very minor stuff, and he was probably just a normal 13 to 14-year-old.
Hormones going wild, yeah.
And he's just starting to enjoy a bit of freedom in his life. But he came down that weekend and was staying with his sister, and he did go out and have a few drinks. Well, they were drinking out of plastic bottles of cider, but he wasn't that intoxicated. One of the other boys broke a window in a shop, and everybody ran. You can imagine the scene, screaming and roaring and whooping up the street, and they ran off. And the guards followed, and arrests were made. 3 boys were arrested and taken into custody. Now, I have a video of one of those boys saying the following morning when he's being interviewed, and he's asked, where did he get these marks on his face? And he said, I was beaten. And he's then asked, and who beat you? And he kind of looks quizzically and says, well, the guards did. The answer to that from the questioning Garda is, oh, I doubt that very much. Now, the other boy in question who survived that night had also made allegations of being assaulted. Brian Rossiter did not wake up in his cell the next morning. He was found to be seizing. He was having seizures, and a doctor was called, and it wasn't possible to revive him, and he was transferred to the local hospital, and from there to the neurosurgery unit in Cork University Hospital, where that was Monday morning, I think, and it was Friday when his family were with him when the machines were turned off. So there were many, many issues in the case. Most of them got clouded. Most of the witnesses involved were teenagers, and they don't tend to make great witnesses or great historians. And what happened that night is not likely that I will ever know. But we do know that he suffered a head injury, which was argued to have been caused by an assault where he was beaten by an adult, a young adult, 2 nights earlier. And really the entire case turned on whether it was a credible explanation for bleeding to death on that Monday morning in a cold cell, that he had been struck to the face 2 nights earlier.
Now, Cian, the autopsy, what was the finding of the autopsy, the inquest into Brian's death? What was the cause of death, rather, written on the death certificate?
It was a factual account of a head injury. So it was clearly caused by a skull fracture to the left temple area, and that led to the rupturing of a delicate blood vessel in the wrong place, and that particular blood vessel caused him to die from internal bleeding within his brain. It did not go into issues of guilt, because inquests are prohibited from making any finding of either guilt or innocence. An inquest, a coroner may not absolve anybody of blame or attribute blame to any person by law.
Oh, I see that. I see. And how often, we won't dwell on this too long, how often did they say that Brian Rossiter was checked during the course of the night? I suppose the usual standard every half hour.
That sort of thing, yeah. And there were various inconsistencies in that, but record keeping, I suppose, if I'm to be fair, I feel where there isn't somebody else here from, you know, with respect that I can't really argue my own case, but I think record keeping is always found to be lacking when it's scrutinized. There were findings from the inquiry of fault on more minor issues. So it was found that his detention was unlawful and shouldn't have happened, and that the record keeping wasn't appropriate, and disciplinary charges were brought against, even though that was a disciplinary inquiry, there were further disciplinary proceedings then brought against some of those members who were before the tribunal. But I don't think anything ever came of that, because they used, incredibly, the Commissioner of An Garda Síochána used the new offences, which had only more recently, since his death, come into effect through the Garda Síochána Act, to charge these men. So they then went to the High Court seeking judicial review to stop this inquiry or this disciplinary process, because those offences didn't exist when they were alleged to have been committed. And I think a first-year law student would have said that that was going to be the outcome of taking newer legislation. You cannot charge and seek to convict me of a crime that I'm supposed to have committed last year on legislation that only passed yesterday. And that hasn't been successfully done, I think, since Henry VIII with his laws of attainder.
That was a bit far back, all right, yeah.
Well, he was very fond of that idea. Let's change the law and then show that you have committed an offence in the past. It's usually treason, and it usually resulted in burn at the stake or having your own trail.
He was a smart man, wasn't he? But
power is a dangerous thing.
The only thing I want to clarify in my own head is, and it's all very, very sad anyway for everybody, particularly for Brian, obviously, and for his parents and his immediate family. But getting back to the idea of, you often see headlines in our newspapers on a daily basis, young thugs are out of control and they throw stuff at guard cars. Now I'm after learning today and that juveniles can be arrested and detained. You know, and why isn't it used so more often when you see young thugs in a state causing havoc?
Juveniles can be arrested and detained, and one of the positive results that came from that series of cases, there were apologies that were issued to the family as well, of course, from An Garda Síochána, but that is not to say that there was an admission of responsibility for Brian's death. The main improvement for the sake of young people, whether they are offenders or not, is that the custody regulations were revised and that there are better checks and precautions put in place to protect young people in custody, including a stronger requirement to have them medically examined. But the Gardaí, in certain circumstances, are entitled, and it would be crazy if they were not, to arrest and bring into custody certain people. What happened on that night was different, and that is that having arrested these boys, the Gardaí then sought parental permission to keep them in for the night to teach them a lesson.
Oh, I have you now. If they arrest minors in the normal course of events, are they obliged legally to inform their parents or guardians that they have them?
Yes, absolutely.
Immediately or after a period of time?
Well, it's at the earliest possible opportunity, not allowing for any unreasonable
statements. But can any statements that they may make before their parents, guardians are informed, can they be used?
No. I think there may be extreme situations in many. We're getting into the area of hypotheticals here, but the Gardaí would be very, very reluctant, I think, to try to take any kind of formal information from a young person in the absence of a guardian and in the absence of some legal advice being given to those persons. But you can always have a situation where somebody is, taken out for a cigarette break to the yard, and at that point they have a conversation with the Garda where they, for example, admit their involvement in some criminal activity.
Yeah.
And that will be noted down and will be used against them. And that is a common enough issue. But I should say that the days of my criminal defence practice are long gone. And these things change. And I wouldn't like to give anyone the impression that I am speaking with some sort of legal authority on these matters anymore. I'm getting increasingly uncomfortable talking about criminal law matters. So
yeah, it's right. And Cian, as you know, Cian O'Carroll is with us here on Lair Confidential on lairmedia.tv, and info@lairmedia.tv is our email if you want to make any comments. And we're delighted to have you, Cian. Before we finish up, the ongoing case that's with you on against Dupuy in the hip implants, the hip cases, so to speak. How is that progressing?
Well, that's been. I was going to say, well, it is. It's something of a saga in that the whole series of litigation that developed out of this defective metal-on-metal hip implant,
yeah,
which came to public attention and worldwide attention with a recall of the product by that company, Dupuy or Dupuy or Dupuy. Various pronunciations. I've generally stuck with Dupuy, but people correct me. That began in 2010,
goodness.
And there was a recall at that stage, and then people were notified. And arising from that, we got involved in quite a lot of those cases. And because we brought the early ones, and we brought all the first case all the way through trial, and we had all the early trial dates, I suppose we had a really good seat in the cockpit to see how something like that works against a major multinational. Probably helped us later in dealing with the laboratories involved in cervical screening. But
Absolutely,
you are up against a big, powerful, wealthy, multi-billion-dollar a year adversary, and they have those muscles that they can flex. But at the same time, we have a really brilliant legal system in Ireland. And I'm not saying that we have really brilliant, representatives for people. That's not the point I'm making. I'm saying the system is incredible here in that it is so fair that most of our clients in another jurisdiction would probably face huge obstacles in getting access to justice with the very best representation available from the finest barristers in the land, and being able to put together international expert opinions to be able to mount a challenge against these types of entities who would be protected by their wealth in other places, and they are not protected by that wealth here. And it's a real system where David can regularly take down Goliath.
Well, I mean, that's a fair point. And how, who makes the initial assessment? Like I go into you tomorrow in your office, and who makes the initial assessment that there is a case to answer by Dupuy, we say?
Well, I can say that we do on a very superficial level, and then you have to get expert opinions to advise you. So often in an issue like that, or for example in cervical check cases or breast cancer cases, you're working on the body of experience that you've built up. So you know that there are certain features that you've experienced in the past which were suggestive of poor care or suggestive of negligence. And so you're probably filtering through for those in the first place, looking at medical records and listening to the person's history. Then of course, you may miss things, and so you have to be mindful of that. And then you want to identify what the key questions are to ask of an expert about this person's care. You're not just taking the ball and throwing it to them and saying, you figure it out. You really are trying to interrogate the questions on behalf of your client. Right. And then you send that to the expert, and an expert in that area needs to be somebody at a pretty high level in their own chosen subspecialty. And usually now I'm talking about a medical negligence situation.
Yes.
The Dupuy ASR hip implant wasn't dealing with medical negligence, at least in the vast majority of cases, because the implants were put in correctly. The problem was in the design and manufacture of the implant. So it was a product liability case.
And you're spending money, of course, your company. You're spending money on behalf of me, who's hoping that the case can be progressed.
Well, no, usually you're spending money, Pat. Usually you would be funding the cost of the reports that go into the doctors.
Or at the beginning?
Yes.
All right, I'd get those bills.
Yeah, we're doing the graft. We're doing the hard work. And then we can do so much.
I like that. You're driving the car and I'm putting the petrol into it, is it?
Exactly.
Yeah. That's a good.
I probably have to get out and push as well, though.
Well, and this you went out on your own anyway in 2010. 10 years down the line, of course, you've been very successful, and obviously that doesn't come easy either. It's a lot of hard work. And how do you look back at the last 10 years, if you can assess it, Cian, of your own business?
The last 10 years, well, it's all a continuum, isn't it? I mean, it starts off with your training and the earlier part of my career. I mean, I got a great training from my old master, John Lynch, who was a solicitor in Clonmel.
Yeah, I was reading what he said in glowing terms about you when you left.
In a newspaper profile. Yeah, I actually also spoke about him in glowing terms, but they didn't write those down, unfortunately.
No.
And you know, you can't be trained and well trained by somebody that you had at one stage an almost father type approach towards, without some level of emotion being there as well. So
of course, yeah.
I worked for him then when I qualified, and then I was all the time learning, and then we were partners for a time, and then I was out on my own then in, as you said, 2010.
Yeah.
So you're picking up things all the time. Isn't that how we all?
Yeah, absolutely.
In life, you're just learning as you go along.
Well, it was Mary. When Mary informed me that you were coming on our show, we were absolutely delighted. Now I knew I'd seen you on television, obviously, but you know you can't make an assessment of a person on television in a 2 or 3 minute clip, you know, and stuff. I read up a bit about you, but I think that overall, there's no doubt about it that you are doing good in a crowded space around the place. You know, you are doing excellent work, and I think you have to be applauded for. It's all very fine to be looking back at the end of a case, but you don't know, as you know yourself, you don't know how it's going to turn out when you go in the door. But you have to be applauded and acknowledgement given to someone like you on a human level to take on these appalling cases that we all read about, you know, and that we put on our newspaper. But you carry those cases for years and years with you, you know, and your firm, and it's a testament to the humanity behind all the trauma that you faced in those cases yourself, you know.
Well, thank you very much. But it's you know, it really is very rewarding for everybody here in the office when you see that you get a chance to work on very important things, and they're important at a personal level for our clients, but they're also sometimes important at a broader health level. And I know people criticize litigation as being something of a curse on the land, but I honestly believe that it does act as a force for good and a force for change. And if it wasn't there, of course, everything gets abused from time to time. But if litigation wasn't there, be it from workplace accidents with improvements in health and safety and oversight, or within the health service, if there isn't some way of holding the system to account, well, then people behave in a less careful way, and that has to be bad overall. But for us, just on the point you're making there, I mean, we're not doing something noble here. We're doing a job that we've learned how to do pretty well. We get huge satisfaction from it, and hopefully tomorrow and the day after, people will still come in the door with an interesting query for us to try and puzzle and figure out, and hopefully bring successfully to them so that they can get redress that usually these injured people really desperately need. You know, these sums that you read about in the paper, and I think again something we didn't touch on, but people often comment on. It was said to me twice in the last couple of weeks, just people I casually met, and they said, well, of course those sums of money were unsustainable that people were getting. The new phrase is payouts, which drives me through the roof.
No, they're not payouts.
No, they're not payouts. This is not winning the lottery.
No.
This is somebody who's dying usually, and they're frightened about what's going to happen to their children. And if we go back to the case of Emma Vic-Fahuna, God rest her soul, that was obviously a very substantial sum that a lot of people commented on at the time. There was a settlement there of 7.5 million euros. The state had costed her damages at, I think it was something like 3.6 million euros. And so the dispute in the case was over the difference, but they costed it on the basis of foster care for her children. And she said, you're not going to foster out my children. So the cost, in order to keep the family together, involving care, property, all of the different elements that come together, not to make a stab at it, and at least keep a family of children together, comes at a cost. And what they did in that case by saying that foster care is appropriate will always, I think, stay with me. And it's a great motivation because it shows you how if people don't stand up, and if she didn't stand up, the wrong that would have been done to so many lives, generations harmed by that. It's not about money. It's about what the money is put to.
Yeah, yeah, and I know the headline is always the money. The headline is always the 2 or 3 or 4 million. Really, people should just read the story, read the circumstances, because they're not all the same. They can never be all the same, as you said. And that really stuck with me. The Vic Nahuna's case was so very sad, very, very sad.
Desperate, and what again? It wouldn't. None of it would have been known without Vicky, because she brought the issue to light, Vicky Phelan. But Emma then herself, she was such a brilliant communicator.
Oh, fantastic.
And she would hone in on some little point and make it so clear. And then behind it all, you had that sense, I think, that any of us who are parents especially, where you couldn't but put yourself in her shoes or try to imagine. No. As she talked about the simplest of fears, that her baby wouldn't remember her.
Yeah.
So
there's no money. No, I don't care, and you probably agree with me, Cian. There's no money can pay for that.
Oh God, no. But that's and again we're back to that point. The damages are capped at 500,000 euros, no matter how severely you were harmed, and all the rest has been calculated carefully by experts on both sides to work out how much does all the other stuff cost. The nurse who's going to be there by your bedside at 3 a.m. because you can't use your arms and your legs. The hoist to get you out of that bed so that you can be washed. All of those things come at a cost. And that's what makes up these large sums in catastrophic injury cases.
The medical care.
It's medical care. It isn't, yeah. There's nobody going around in a sports car.
Oh, absolutely not, no. Cian, I was absolutely delighted to have you as our guest on Lair Confidential, and we wish you the very best. I don't like to say success because of the area of work that you're involved in. It's not a question of money anymore. It's a question of the humanity behind your firm, and just looking up some of the bios of the lads. I mean, the dedication that you put in and the hard work you put in and the challenge that you face in these cases. I don't know how you do it, because I know certainly I wouldn't be cut out to do it anyway, But it's a compliment of the humanity of the firm that you front up, and of yourself, of course. And it was an absolute pleasure, Cian, to have you as our guest here, Cian O'Carroll, on Lair Confidential. So till we meet again, goodbye and good luck.
Thank you, Pat.
I'm very proud of the work we do here. People come to us with a problem. Either they or a loved one have suffered harm from the medical care that they received, and they're looking for answers. Either they haven't received any, or they don't believe the answer they did get. Most of the time our work is figuring out the right question to ask. We then put that to a leading independent medical expert and get answers for our client. We try to figure it out, and if there's a case, then we work hard on that, we fight it, and we win it. When you put it like that, it sounds quite easy, but it's often complicated and hard. We have a great team here, a friendly and happy team, and I think we all share that common interest in winning and getting the best result for our client. Success for our clients doesn't always mean taking a case. Often there's great reassurance in being told by an independent expert that the injury was not caused needlessly, and that can make living with the consequences so much easier. If, however, the expert concludes that there has been a failure in their care, well then they are entitled to seek redress. for care costs, for pain and suffering caused. And if we're instructed to do that, we fight it all the way. I think to consistently win cases, you have to understand the details, both legal and medical. We're lawyers, not doctors, but we have to understand enough of the medicine to ask the right questions and understand the answers, and then put that into its correct place within the law.